Okay, good afternoon, everyone. My name's Nigel. Thank you very much for taking some time to join us this afternoon as we go through some material on a topic that obviously is very recent and very important to all of us. So in this presentation, what I'd like to do is touch on the Temporary Measures Act, which has come about recently, passed in Parliament on the 8th of April. And I will touch on some of the regulations which affect businesses, individuals, and guarantors. First, of course, I'll just lay out the landscape for everyone to be on the same page. And as I said, I will then go into the regulations and the Act. And then I will deal with two types of scenarios. The first being where contractual obligations can be suspended. And then the second being where obligations are enforceable during this period. And when I say this period, I'm referring to the initial relief period from the 20th of April to the 19th of October this year. Thereafter, my colleague Eugene will touch on some of the developments in the conduct of meetings which are required by statute or written instrument. And then we will go through some of the measures which we suggest that businesses look at and possibly for taking action now. Then, of course, we'll go into a panel discussion where you would be free to ask any questions you like, and we will do our best to respond. Now, first of all, businesses have been bracing themselves since 2019. It was sometime in August that we saw news about the potential for some distress in the bond market. There's 12 billion of bonds due for maturity this year. And we also saw that the global economy was suffering from the trade war, and imports and exports were affected, as well as the construction and services sectors. Then sometime in the course of this year, the COVID-19 fears, came to our doorstep, and we started to see travel restrictions, a drop in aviation, shipping, logistics, and of course, where we are today. In April, this month, in the middle of this month, you would have also observed that oil prices had dropped on account of oversupply and just insufficient storage globally, and that has also put a spin on what we are facing in our businesses. I'd like to highlight some of the important dates to bear in mind. The first of all being that on the 1st of February, there was an MTI advisory, Ministry of Trade and Industry advisory for businesses to implement safe distancing measures. And on the 25th of March, the enhanced safe distancing measures came about, and they were enforceable from the 25th of March. On the 8th of April, the COVID-19 Temporary Measures Act was passed by Parliament in one of all three sittings were held at the same time, and the control orders, which were specifically for enforcing safe distancing measures, those were put into force right away. Certain other obligations and provisions under the Act were not implemented right away. The Minister gazetted regulations for those on the 20th of April, so that's another important date to remember. And of course, on the 21st of April, you remember the announcements in the afternoon about our escalated control measures. So just to give you an illustration for purposes of discussion as we go along in this presentation, this illustration is meant to identify some of the issues which businesses are facing. Let's look at Alice and Bob, who are directors. Now in December, they agreed to supply materials for Carol's house renovation. That's great. Since February, Carol has not paid them for completed work. And now the company has directors who are overdue. Now the thing is, the company V is also due to deliver certain materials to another project down the line. Some questions which arise would be, well, first of all, what are Alice and Bob's duties as directors? Is there anything in particular they need to take note of? Can they press Carol for payment? Will they still have to deliver materials on the 14th of May? Can they pay creditors who are friends but ignore other creditors? What can creditors do in general to recover debts from Company V? Now, in the extended scenario where Alice persuades Chuck to extend a short-term loan to Company V, can Company V, which has already secured loans with a bank and maybe another unsecured loan with another bank, can Alice actually go ahead and obtain that loan? Now, in an additional scenario, what if Company V also leases storage space? What other obligations are they bound by? Can Alice borrow money from Chuck? What if Chuck's money is used to pay salaries of the directors and not creditors? Does it matter that Alice can actually promise repayment? So these are some of the issues which we think businesses face, and we will go through them in the course of this presentation. So let's first look at the Temporary Measures Act. It was passed on the 8th of April, and there is an initial relief period for 6 months up to the 19th of October, but the Act will allow the minister to extend or shorten this relief period. The full period for which the Act may be enforced is for a period of 1 year, which is up to the 7th of April next year. Now, this is a framework of the provisions which were covered in the Act. First of all, I would like to draw your attention to the temporary relief for inability to perform contracts, which came into force on the 20th of April. The conduct of meetings, which actually was retrospective to the 27th of March. And of course, certain other control orders, which were effective from the 8th of April when the Act was passed. So on the 20th of April, the regulations which came into force largely deal with the mechanics behind how a party seeks relief under the Act. And we will go through some of these, in particular, how a notification for relief is filed and how an assessor is appointed in the event there is a challenge to that request for relief. So first of all, I'd like to deal with the suspended obligations. In this first scenario, there are certain requirements that have to be met. First of all, the contract must be one of 5 types of scheduled contracts under the Act. Second, there is a time requirement. The contract must have been entered into or renewed before 25th of March 2020. You'll recall that the 25th of March was the date when Parliament set certain enhanced safe distancing measures. Then there is another time requirement. The particular obligation which cannot be performed must be one that is due to be performed on or after 1st February of this year. And that inability to perform that obligation must be due to a material extent to a COVID-19 event. Now, of course, the procedural requirement is that a notification for relief must be served properly using the system which the Ministry of Law has implemented to all the parties of the contract, including guarantors. Government parties can also be parties to scheduled contracts, and scheduled contracts are generally in writing. They may have been concluded by way of an exchange of correspondence, but there is a question mark as to whether contracts which are already concluded can actually fall within one of the scheduled contracts. I will deal with that as we go along. So just touching on the 5 types of contracts. First, we have to look at non-residential leases and licenses of immovable property in Singapore. So these are the types of contracts where you would normally see a commercial tenancy, warehouse space, shop fronts, and that sort of premises. In a situation like that, if a tenant does not make a payment, then what happens is the landlord might ordinarily be entitled under the lease to exercise a right of forfeiture, to re-enter, to distrain for rent, or to seek a judgment in court against the tenant, to start insolvency proceedings, which would be either bankruptcy against an individual tenant or winding up against a corporate tenant, or to simply seek repossession of the premises. But under the relief provisions, the defaulting party who doesn't pay rent can seek relief to suspend obligations for up to 6 months during the relief period. Now, the second type of scheduled contract relates to construction or supply contracts, which are defined under the BCI Security of Payment Act. First of all, in that scenario, the defaulting party would be unable to meet the delivery or completion date, for example. And of course, the innocent party in this case would look to that and say, ordinarily, I can obtain a judgment, or I can start insolvency proceedings, or I can actually call on a performance bond. But the relief that's sought by the defaulting party can result in a moratorium, so prohibited legal action cannot be brought against that defaulting party, and a call on the performance bond can actually be delayed. Now, in a situation where party A has actually already obtained the benefit of a performance bond, they can actually seek the extension of that performance bond. In general, for construction and supply contracts, a delay period during the relief period will not be included in the calculation of liquidated damages. And if there is non-performance during the relief period on account of the COVID-19 event, then that can amount to a defense for a breach of contract claim. Now let's go into the other two types of scheduled contracts: events contracts and tourism-related contracts. They are defined separately, but the key characteristic in relation to these contracts is the way in which deposits are dealt with. The primary principle here is that a deposit must not be forfeited unless the assessor comes in to determine what is a just and equitable deductible portion. And of course, in terms of cancellation fees for an event, if the COVID-19 event gave rise to that cancellation, then that would be a defense in a claim for cancellation. Now, the fifth type of scheduled contract, well, that would relate to the secured loan facilities granted to certain SMEs or in relation to hire purchase commercial agreements. Let me explain the first. SMEs who may gain the benefit of the temporary measures would first of all be SMEs defined as enterprises under the Act. And enterprises would be entities with at least 30% of their shareholders being Singapore citizens or Singapore permanent residents, with an annual turnover not exceeding 100 million. Now, in that scenario, if the defaulting party doesn't pay on the secured loan, then the beneficiary of that loan would not be able to, the beneficiary of that security would not be able to enforce that security. And that again is for the relief period of 6 months. In a hire purchase scenario, if those goods are intended for commercial purpose, then the right to repossess can be suspended if the notification for relief is raised in relation to a scheduled contract. And to give you an idea of the type of legal action which cannot be brought against a party who files properly for notification of relief, this is the type of legal action that will be suspended. First of all, any court action or domestic arbitration proceedings which are ongoing, the enforcement of any security over immovable property or commercial goods, the making of a scheme application under Section 210(1) of the Companies Act. This is for directions for the company to make a proposal to its creditors. The making of a judicial management application, a winding up application, a bankruptcy application against an individual business owner or guarantor, the appointment of a receiver over any property, and any other enforcement action that may be taken against goods or assets pursuant to some enforcement proceeding in court. Now, there is an exception if the court grants leave in relation to execution distress. And I think there we are looking at scenarios where an asset might be dissipated if enforcement is not pursued. Now, what I think is important to also note is when a scheme application under Section 210 here is actually deemed a prohibited legal action, one must note that the Section 211B type of scheme application is not prohibited. So companies that are seeking relief, they're seeking some protection space or a moratorium, can actually make an application under Section 211B. And to complete the list of prohibited legal action, specifically in relation to the re-entry or forfeiture under licenses or leases, or the enforcement of judgments and arbitration awards, those are also prohibited. The consequences of taking prohibited legal action are really in two respects. One, of course, the avoidance or declaration of certain proceedings being void. But the other is that there can be an offense. So this is potentially a criminal liability as well. And a party who actually gets the benefit of a suspension, that suspension does not prejudice the other party who has a cause of action. So it would extend avoidance look-back periods. It would extend periods of time when certain floating charges or liquidators' powers might be otherwise prejudiced. And the temporary measures do not affect the rights of any other action in relation to a force majeure clause or the Frustrated Contracts Act. So graphically, just to let you know, there are 4 main dates to bear in mind. The first being 1st February, for which an inability to perform the obligation must arise. Then, of course, it must be in relation to a contract that was concluded on or before 25th of March 2020. Then, of course, the 19th October is the end of the first 6 months that we are looking at for the relief period. And the act itself is in force for a period of 1 year up to the 17th of April 2021. And I have put here the types of contracts or non-scheduled contracts which may be suspended. And you will see the ones in light blue. Those are the types of contracts which can be suspended. So quite a number of scheduled contracts entered into after 25th of March, or non-scheduled contracts entered into at any time. Those types of contracts do not gain relief under the Act. So in terms of the procedure to seek relief, because the procedural requirement is a key requirement, there would first need to be a notification for relief filed. This, of course, assumes that the eligibility for relief has been determined by the particular business owner. The filing process is done online by electronic means. There is a portal set up by the Ministry of Law, and you require a SingPass for an individual or a CorpPass to gain access and to submit the relevant information into a prescribed form online. You need to identify the parties to the contract. You need to identify the correspondence or actual document that form a contract. And you will need to look at the actual event which caused the inability to perform a particular obligation. This will have to be explained in that form. The procedure to challenge a notification for relief is actually limited time. So if you wanted to challenge a notification, you didn't believe, for example, that your counterpart ought to be seeking any relief, then you would have to file in relation to an event contract, a tourism-related contract, a construction contract, or a supply of materials contract. You would have to file within the this period, the time beginning for the relief period and ending at the end of 2 months, after the end of the relief period. So that would be the 19th of October plus 2 months. Now, the procedure for challenging a notification for relief is really to get an assessor appointed. So the first step there is to consider, what are my grounds for challenging a notification for relief? Is this a case where the debtor was already unable to pay me, not on account of a COVID-19 event, but because of some other financial distress? Was this a situation where he actually is able to pay other parties and he's just choosing not to pay me? So if it's not materially caused by a COVID-19 event, then there is a possibility that a challenge can be brought. For a challenge to be brought, the procedural requirement is that the application for an assessor's determination must be filed through the electronic system I mentioned before. Then, of course, the registry will look at this, and if it's in order, send a response form to the respondent party. So as you can see, everything is done electronically. It's important for the parties to identify email addresses correctly. The applicant must then ensure that the documents are served properly, and the respondent will then have a period of 5 working days to submit a response electronically. Now, if that doesn't happen, the respondent will have a few options. One, of course, is to ask for an extension of time. The other, if he's too late and the determination has already been made, he may have the only limited choice of applying to set aside the determination of the assessor. So let's say the party that's objecting has already filed the application to challenge the notification for relief. The assessor is then appointed, and what happens after that is the hearing is held. Now, the hearing may either be held by way of exchanging emails or may actually be in person. If an interpreter is required, the assessor can give permission for the interpreter to be used. And of course, if further documents are required or if clarifications are needed to clarify what a party means in their application or response, then the assessor can make those directions. So there is flexibility for the assessor to conduct a fair hearing. While the hearing process has been initiated, if parties have ongoing court proceedings or arbitral proceedings, then it's incumbent on the party who's challenging the application to update the court or tribunal and notify them that a notification of status, right, has to be filed. Now let's go to the second scenario. Let's say your contracts are not covered as a scheduled contract. And what happens? During this relief period from April to October, there are limited types of relief available. And specifically, I'll identify three. First, if a creditor wants to take action against a debtor on a non-scheduled contract, and that action is going to be a winding up application or a bankruptcy application, then there is a monetary threshold that must be met. The usual thresholds are 10,000 and 15,000. But in this case, the thresholds have gone up to 60,000 and 100,000. 100,000 being for winding up application. So that's the first thing that has changed. The second thing is if an application is being made during this relief period and a statutory demand is to be served because the creditor intends to rely on the inability to pay under a statutory demand as proof of insolvency, then that statutory demand must have a 6-month period for the debtor to comply, not the usual 21 days. The third thing that is brought about for enforceable obligation is really in relation to the conduct of directors or officers of the company or individuals who may be incurring credit in the course of this relief period with no real expectation of repayment. Now, the Act deals with this, what we refer to as insolvent trading. The Act deals with this by placing a defense where a party has done that, is not deemed to have no reasonable or probable ground of expectation of not being able to pay that debt. So the mental element, the mens rea, as we call it, is dealt with in this way. Now, there is a fine line sometimes in assessing whether the conduct of a particular officer was insolvent trading or if it went further as fraudulent trading. And fraudulent trading is not protected under the Act. So while we have this provision in place, there may come across a question where the conduct of a director might be construed by certain creditors to have been fraudulent. Now, one other observation that we've made is that prior to the 20th of April, a debtor may have received a statutory demand that prescribed a 21-day period for compliance instead of what is now required being 6 months. So in that case, the creditor at this point in time would actually be in a position to rely on that 21-day SD, which was issued prior to the 20th of April. That's just an observation of some unique situations which you may come across. So if we go back to the illustration, you will see that after having gone through some of the material earlier, Alice and Bob as directors will have to have certain duties to take into account if they are insolvent, if company V is insolvent. They will have to be careful about who is paid and who is not. Can they press Carol for payment? Well, possibly. We would have to see if the contract is a supply of materials contract and if Carol would actually want to claim relief under the temporary measures. Will they have to deliver materials on the 14th of May? Well, if that is a supply contract as defined under the Act, then they may not have to. They may apply for suspension of that obligation. And in terms of creditors, can they do anything to try and recover debts from company V? Well, there may be options available to them. If it's not covered under the Act, then the enforcement of those contractual obligations can actually still be pursued. Now, in terms of seeking short-term loans from Chuck, well, that may be possible, provided that the other banks and their rights in relation to, say, all monies charges or negative pledges or first rights under security, if none of those are prejudiced. And if company V has leased storage space and is unable to make a payment due to a COVID-19 event, then the question, of course, is whether company V intends to put in an application as an enterprise to seek relief from the landlord. Okay, now let's move on. Now, in relation to the conduct of meetings, which are required by statute or instrument, there have been significant developments, and I would now like to hand over to my colleague Eugene to run you through some of these developments.
Thank you, Nigel. We shift gear for a while now to talk about the conduct of meetings. And with the promulgation of the COVID-19 temporary measures, alternative arrangements for meetings order, which was promulgated on the 13th of April 2020, the ability to use alternative means to hold general meetings has been given the force of law. Do note that this order was amended slightly on the very next day, on the 14th of April, just to clarify how notices of meetings must be served on shareholders. But by and large, if you read the 13th April 2020 order, it will contain almost all that you need to know about the holding of meetings under these alternative arrangements. As Nigel mentioned earlier, the order is deemed to have taken effect retrospectively from the 27th of March 2020, even though it was promulgated on the 13th of April. Now, the duration currently envisaged by this order is from the 27th of March until 30 days after the end of the control period under the COVID-19 temporary measures, control orders, regulations. But do note that actually the order provides for alternative arrangements all the way up to the 30th of September this year. I think that is prudent on the part of the government because given the very dynamic situation that we are facing, it certainly cannot be excluded from the realm of possibility that the control order could be extended again. So, you have all the way until the 30th of September. If things go on beyond that, then Parliament may have to pass an amendment order to extend it. But otherwise, currently the order as it stands will be good all the way until the end of the third quarter of this year. So what type of meetings are covered by this order? Well, it basically applies to general meetings. In other words, meetings generally of shareholders of the company. It covers companies, it covers variable capital companies, the new entity that has been created by statute, VCCs as they call it. It covers business trusts, it covers unit trusts, and also important to note, it covers debentures, holders of debentures, bonds or notes that are issued in Singapore under Singapore law. So to that extent, these arrangements can be used for creditors meetings as well. I mean, in a case where you have debenture holders and a company is facing difficulties, servicing or repaying the bonds, creditors or the trustees can actually use these means to convene a creditors meeting for the debenture holders. So, what is primarily the means to hold these alternative meetings? Well, the order now expressly allows for participation by audiovisual and audio-only broadcast. Do note that it is stipulated that you need to provide both audio and visual, as well as an alternative for audio only. In other words, you must provide the facility for audio-visual participation, but of course the participant can dial in, just to choose dial in using audio only. That's possible. Now, as far as the number of people attending, well, this one is mainly pertaining more to public listed companies in Singapore. MTI, the Ministry of Trade and Industry, has granted an automatic time-limited exemption for up to 6 people to be physically present in one room at one time, provided the safe distancing measures that the government has put forward are observed. So you have to sit at least 1 meter apart and things like that. The procedure is quite simple. The company just needs to notify MTI of the date, time, and venue of the meeting at least 1 day before the meeting is convened. And they just do this, as with most things, by just going to gobusiness.gov.sg and filing this notice with MTI. So this notice of meeting, how is it to be served? Obviously, by post is probably not going to be the most efficient way. So it actually provides for you to serve your notice of meetings by way of email. Of course, provided that the email addresses of each of the shareholders have been provided to the company. And if the company has a website, you should also publish your notice of meeting on the website. For public listed companies, again, the notice must also be published on the SGX net, as with all announcements that the company makes, and also on the issuer's website. I think most listed companies probably will have a website. The notice period is the minimum 14 days, excluding the day of notice and the day of the meeting. But I think the SGX has urged listed companies very strongly to provide at least 21 days notice. And I think the reason for that is also, as I'll cover later, is to do, I think, with the raising of questions. It's not so easy to pose questions to the company under these arrangements and to receive responses. So I think the SGX has strongly urged members to provide for 21 days notice, even if there are no matters to be considered under special resolutions, even if it's just ordinary resolution. I would strongly encourage you to read, as you can see at the top of this slide, one thing that we mentioned was the joint statement by ACRA, MAS, and the SGX released on the 13th of April, the same day the COVID-19 measures for meetings was promulgated. Because this statement supersedes all prior statements that were released either by MAS or by ACRA or by the SGX. So at the moment, this is the defining statement as far as the conduct of meetings are concerned. And if it's difficult to read through the statute, the order, then just by reading this joint statement, you actually get most of the information that you actually need to understand what you need to do. So I would urge everyone who is involved in organizing or participating in company meetings to actually read this joint statement released on the 13th of April. So this joint statement, one of the things covered by this joint statement is the contents of the notice of meetings that are published. What must you say in your notice of meeting? I mean, apart from the usual things, the agenda items and all that, you must provide information about the electronic means by which the meeting will be conducted, or in simple language, how to dial in, right? You need to provide instructions, clear instructions to members and shareholders and other participants, how they can dial into the meeting. That's very important. Then on the matter of a quorum for the meeting, again, you cannot gather people in a room. So how do you determine the quorum? Well, the order actually provides that the quorum is only 2 people. So no matter what is otherwise stipulated, as long as you have 2 people, that forms a quorum. Now, if your constitution of your company actually provides for 1 person to be a quorum, that is also fine. And on top of that, to make it even easier, attendance by quorum members can also be by electronic means. So you don't need to have 2 people sitting in one room. A person dialing in to the meeting can also constitute a quorum. So it's very, very easy to be able to convene the meeting because the quorum requirement is very easy to meet. And I think one of the very important questions that people do actually ask recently is, how do I vote then, right? Because it's by remote. How do I cast my vote? And the thing is that, well, unless your constitution of your company already allows for remote electronic voting, actually this is unlikely because obviously this scenario that we're facing now is probably not envisaged by most companies. But secondly, also the technology for this is still being developed. It's not widely available, although so there are certain parties, including ourselves, who are actually in the process of developing software to actually run this remote voting. But I think the regulators acknowledge that, practically speaking, at this very moment, is probably very difficult to do. So what they've provided is that they say everybody will then just have to cast their votes by way of proxy. And not only that, you can only proxy the chairman. So you cannot proxy another member to vote in favor of you, to vote per your directions. You have to proxy the chairman to do so. And you have to stipulate, obviously, in your proxy form, exactly how you want the vote to go. So either you want it to go for or against a particular resolution. That must be stated very clearly in your proxy form. This instrument of proxy can be sent by post and by email. So if you can just email the chairman, that can be collated with the other proxy forms, and he will cast your vote at the meeting on your behalf. The next point deals with questions. That's another question that we do get, as in, so how do I pose questions to the company? So again, because this is not interactive, it's not live technology, I think in many cases, it doesn't yet allow for you to actually participate. Imagine, if you have a meeting with 100, 200, or even 1,000 shareholders, you can't have everybody trying to talk to your computer screen at the same time. So again, it is stipulated that questions must be tabled by way of sending the chairman of the meeting, again by post or email, within a reasonable time before the meeting, the matter or matters that you want to raise. And it is also stipulated that if it is a substantial and relevant matter, this has to be responded to by the company at or before the meeting by electronic means. So either the company actually deals with the query ahead of the meeting, or it actually posts during the course of the meeting, or the chairman, for example, or members of the board or management can actually answer the question that's posed. Obviously, you have to read the question out first, and you answer the question at the meeting itself. Okay. Now, the period, for most companies, they say a reasonable time before the meeting commences that you have to send your questions in. But for listed companies, for SGX listed companies, it is stipulated that the period will be 72 hours prior to the convening of the meeting. So this follows sort of the proxy form requirements that you have to post your questions at least 72 hours before the date of the meeting. This whole arrangement is not perfect. It is acknowledged it's not perfect, because you lose that live Q&A, as you stand on the floor, ask the questions, get a response, and then form a view, and then cast your vote. So I think due to current limitations with technology and logistics, this is probably the best that the regulators can come up with, and I think it works reasonably well under the circumstances. But as with the evolution of technology, maybe one day you can actually have a virtual meeting where everybody does appear virtually in a room, and you can have an instantaneous Q&A session. But at the moment, that is not yet feasible. As far as the minutes of meeting from that meeting, again, for private companies, it's not so explicit, although I would suggest that at the end of the meeting, with all the Q&A and all that, minutes are compiled and then maybe circulated to all shareholders so that they know what has happened. Again, you don't have that immediacy so as when you're sitting in a room, so you don't actually get to hear the Q&A. So if you receive a copy of it, I think that would be helpful. But for listed companies, again, for public listed companies, the requirements are more prescriptive. The minutes of meeting must be published within 1 month after the holding of the general meeting, and it must be published on SGXNet with your announcement, as well as on the company's website if they have one. And these minutes should record the substantial and relevant comments or queries that shareholders have raised, as well as the responses that the directors and/or management have given to such questions. So logistically, I think particularly I think we may have some company secretaries who have dialed in to this seminar session as well. That puts the timeline for you to churn out, to generate these detailed minutes of meeting, much more rapidly. Because I know sometimes in the current situation or before this situation, sometimes some companies take even a few months to actually publish their minutes, and many companies actually don't actually publish their detailed minutes at all. But I think now, because of this arrangement, again, the rationale is probably that because in these virtual meetings, shareholders don't have the benefit of hearing the Q&A in a room. Therefore, the SGX has stipulated that detailed minutes ought to be published, and they ought to be published within a month after the holding of the meeting. That is all I have, and I will hand the presentation back to Nigel. Nigel, please.
Eugene, thank you very much for bringing us through those updates. Now, if any of you have any questions relating to the details beyond what Eugene has said, or if you're curious about the AGM facilitation grant, then by all means, please put in your questions at the end of this session. Now, let's move on to the next part. So let's first of all look at the scenario after COVID-19 as we see it now. We have a relief period that will run us through to the 19th of October, but we have also seen that there are a number of contracts that may not be covered by the temporary measures that are available. So what could possibly happen after the 19th? Well, first of all, we might very well see that receivables have piled up. We might actually have issues with employees who, may have paid or taken pay cuts, or the relationship with employees might have been affected somehow. Now, everyone's trying, of course, to preserve those relationships with your debtors, your creditors, your employees. At the same time, there's also a need to monitor the secured loans and the insolvency risk which directors might be personally responsible for. So all that is under the microscope and being looked after. So this cascade of debt or cascade of issues might surface after the relief period comes to an end. The second, of course, is that when it comes to the premises that a business uses, its goods, its equipment, and of course, at the end of the day, the product that's being delivered, we know that there are certain ongoing risks. The question, of course, is after the relief period, will a party exercise a retention of title clause? Will there be an enforcement of security? Will there be rights of re-entry and forfeiture exercised in relation to premises? So these are ongoing concerns, just like how directors in their position in the company would have to be cautious about protecting not only the interests of their existing stakeholders, but in a situation where an insolvency risk arises, directors then have a fiduciary duty to take into account the interests of creditors. And there are certain principles at law which apply to these scenarios. The pari passu principle, which requires that a company's assets be distributed fairly among its creditors. The anti-deprivation rule, which is an old English law rule that requires directors or officers of the company not to dissipate assets to the detriment of creditors. And of course, there are statutory provisions dealing with unfair preferences and undervalued transactions, which we would have to look at. The time for inquiry might very well arise after the 19th of October. So bearing in mind that these are things which might arise, is that something that we can do now? Well, first of all, in terms of certain private solutions or private debt restructurings or workouts, that could be an option for some businesses. Businesses might look at funding options, getting short-term finance, looking maybe at asset monetization, sales and leasebacks of premises, or considering whether there's a need to issue bonds to raise funds. Or businesses may also consider a consensus option of telling its creditors, its limited list of creditors, to agree to a standstill, and then to try and work out an arrangement where creditors are paid back. Hopefully, all creditors are known to the company when this process is undertaken. Or we might see a bailout option for certain businesses. They may look at getting shareholders' support, shareholders' repayment of its creditors, and then, of course, there remains just one interco loan with the shareholder. The question then, of course, is whether that will be written off, or if the subsidiary might actually be wound down. Now, in some situations, after the COVID period is over, companies may need to take moratoriums to protect themselves from creditor action. So in a scheme of arrangement, the directors remain in control of the business, and when they put forward an application for a moratorium, it can be under Section 211B of the Companies Act. As I mentioned earlier, that is something which is not a prohibited legal action in the suspension period. As for judicial management, in a situation where creditors are very concerned about the company, they may require that the company pursue a judicial management process. Now, another thing which might happen to businesses at the end of the session of the relief period is that they may look at the business failure and decide to just put the company into a liquidation process. So what can businesses actually try and do now? What can guarantors try and do now? Well, first of all, to consider the strengths of the business and to identify ways, if possible, to innovate or to identify alternative revenue streams. You've seen a number of businesses that have gone online to support their usual channels. Then, of course, managing cash flow is key. And there are ways to do it. There are also ways to try and monitor the insolvency risk and to urge debtors to try and pay up something during this period of time. There might be an incentive given to a debtor. Now, of course, a company that's in insolvency risk will have to take into account whether those might give rise to preferences or not. But then again, we have to reimagine how our relationships with debtors and creditors are and will be, and what might be the best way for a business to survive this period, to have that resilience to move forward, and to be able to eventually thrive post-COVID. And along the way, as we go through this period, officers of a company, business owners will need to take into account if governance and compliance are fulfilled, those obligations are fulfilled. At the same time, if the duties that they are charged with are properly discharged, if they monitor insolvency risk properly, and as I said before, if conduct in selecting some creditors over others or in managing credit might put directors' conduct into the ambit of fraudulent trading, and that's something which must, of course, be avoided. And finally, partnerships with creditors and other stakeholders should also be pursued, because at the end of the day, if there is ample communication at this stage, then that can result in negotiated rehabilitation or repayment plans that will allow a company to move forward and will not give concern to a creditor who may then take out winding up applications from the 20th of October onwards. So those are some considerations that we thought we'd like to bring to your attention.